Welcome, everyone. We're really excited that you are able to join us today, either live or if you're going to be watching at a later time on the recorded session. So one of the reasons that the Council really wanted to pursue this topic today is just the sheer amount of information and activity surrounding ADA compliance here in Arizona over the past year and a half. So we're really excited about the group of presenters we've assembled today, and I know they're going to provide great insight and information that you will be able to go back to your workplaces and put to use right away. So I'm going to provide a brief overview of our speakers today. And first up, we have Brett Heising. Brett brings a lifetime of experience to his role as founder of BrettApproved.com. It's a travel and entertainment website for anyone with a physical disability or a mobility challenge. He was a successful journalist and a PR pro before he turned entrepreneur. Brett is very active in the Phoenix startup community, and he is also a global speaker on the subjects of diversity, entrepreneurship, and accessible travel. He's also a proud graduate of the Ohio State University. Next, we'll hear from Bruna Petrini. Bruna practices in the areas of accessibility, anti-discrimination, and education law at Fennemore Craig here in Phoenix. She helps builders, developers, universities, hotels, and other businesses comply with accessibility requirements and in ADA and fair housing litigation. Bruna previously worked as chief counsel of the Civil Rights and Conflict Resolution section for the Arizona Attorney General's Office, and she has also taught at the Sandra Day O'Connor College of Law at Arizona State. Finally, we will hear from Rose-Daly. Rose has practiced civil rights and disability law for 23 years, first as an attorney at the Arizona Center for Disability Law, and later as an assistant attorney general and unit chief counsel for the Arizona Civil Rights Division at the AG's office. But now Rose is back at ACDL, and she serves as legal director there. She regularly represents people with disabilities in cases involving discrimination in employment, public accommodations, government services, and fair housing. She also teaches at the University of Arizona. So without further ado, I am going to pass things off to Brett Heising.
Hey, thank you so much, Sarah. It's an absolute pleasure to be with everyone today and to tackle the topics that we are, because they are very important. So I thought to myself, I could tell you about Brett Approved and the origin story, or I could share a video with you. It does a really good job of sharing who we are at Brett Approved Incorporated and what we do. So without further ado, John, if you would be so kind as to play that video, and then I'll pick up when that's done.
My name is Brett Heising, and I live life on wheels, but just because I'm sitting down doesn't mean I'm sitting still. About a year ago, I was in San Francisco on business, and it was my job to make the hotel reservations. I called the hotel to be sure my room would have a roll-in shower. "No problem, sir. We've got you covered," they said. "Great." I called again a couple days before we arrived to confirm. But when we got there, you guessed it, there was no roll-in shower. I explained the gravity of the situation to the hotel manager, and they found me a room all right, in a different hotel. Needless to say, I was pissed. What if there was a travel and entertainment website where people with disabilities could review hotels and restaurants and book accessible accommodations? That was my aha moment. But just to be sure, I did some research, and I found out that there are 54 million people in this country with permanent physical disabilities or some type of mobility challenge, and we spend roughly $13.6 billion annually on travel and entertainment. That's when I knew I had to do this. The world needs Brett Approved. No more showing up to your hotel and discovering that it won't work. No more eating at just a few restaurants because they're the only ones you know of that are accessible. No more going to a venue and being surprised by less than stellar accessible accommodations. BreadApproved.com is a standalone website that will help us do everything from book travel to decide if the new bar across town is a place we want to meet friends after work. You'll be able to quickly decide if a destination meets your needs based on its breadth score, a numerical rating system you help create and influence with each review. To make Bread Approved a reality, I need you. Together, we're going to change the world one review at a time and help people, regardless of their disability, travel confidently. Our journey starts today. Let's do this!
All right. So I'm happy to report that that video was done in 2012, and since then, the numbers around people with disabilities in travel have increased significantly. So I'm going to talk a little bit about the market in travel, and then of course, kind of the market overall. So this deck that we're looking at today, that's incorporated into the rest of the presentations, is a bit dated, I must admit, but I think it definitely will still serve a purpose. And certainly want to make sure that if you have any questions post-presentation, I am available via email at brett@breadapproved, and I'm happy to answer any follow-up questions that don't get addressed during our time together today. So there are roughly 57 million American adults with some type of physical disability in the United States. And over half of those, people over the age of 65, are already mobility impaired. But until Bread Approved came along, there was no travel and entertainment website that adequately met the needs of travelers with disabilities. So before I started this thing, I looked at the market. So if I'm going to leave my job, which I did as a successful PR professional and journalist and all that fun stuff, and start Bread Approved, I needed to make sure that the market did exist. And so we just talked about how many folks in the United States, adults, have a disability. But Open Doors organization out of Chicago tells us that in 2011, and again, this number has gone up, there were about 37.1 million trips taken, and that number has increased dramatically. I believe it's up to almost 44 million now. And we spend on travel and entertainment people with disabilities about 17.4 billion. So again, that number has gone up dramatically. But here's the really cool thing, is that people with disabilities do not travel in vacuums. So when you consider that we travel with colleagues, friends, loved ones, etc., our total impact on travel in the United States is 34 point, I think, like $6 billion. So people will say to you, in the world of entrepreneurship, that's a niche market. And to some extent, they're right, it is. But again, it's a market that's growing, and it's a market that really needs to be paid attention to. So this just gets in a little bit about how Bread Approved works. So Bread Approved is predicated on user-generated content. Basically, what that means is we rely on our users. We've got about 5,000 users at this point. We rely on our users, and I think of those users we have, in terms of reviews on the site, we've got about 3,000, give or take. And so we rely on them to provide the information in terms of accessibility for restaurants, hotels, or entertainment venues. And the reason we're predicated on user-generated content is quite simply because having a disability is very personal, very, very personal. So I've been in a chair my entire life, and I use a manual chair. So what's difficult for me may be easy for someone in a power chair, and what's easy for me may be challenging for somebody else. So it's very important that in terms of disability, we look at the spectrum from a very personal point of view. And so what you can do is jump on breadapproved.com, create a free account, and then if there are restaurants that you enjoy going to because you know they're accessible, review them, take some pictures. It kills me to say this as a former journalist, but pictures are worth 1,000 words. And so, when I'm in Silicon Valley securing investment, the question is, who's our competition? So we have direct and indirect competition. And really what I want you to focus on in this slide is the secondary market. So essentially, we're Yelp and TripAdvisor for travelers with disabilities. And so I want to talk a little bit more. I shared the stats about travelers with disabilities, but I found this very interesting statistic, and this was courtesy of a disability think tank out of New York City. And this gentleman produced a report in 2016, and he said that the vast majority of people with disabilities, 71%, have non-visible disabilities such as learning or cognitive challenges. So I think that's very, very important for business owners to realize, is that there are only about 4.4, 4.5 million wheelchair users in the United States, but and that's typically what a lot of the uninitiated think when they think of people with disabilities. They think of chairs, et cetera, et cetera. But disability spans the spectrum. So it would be in every business's best interest to realize that consumers with disabilities span that spectrum, and the responsibility of the business owners is to really say, to yourselves, do I want to be part of this market? Whether it's travel, whether it's dining and entertainment, or whatever it is. I mean, the market is growing. So I will, kind of touch on baby boomers too, because that really gets to the heart of some of those statistics. Baby boomers do not self-identify as having a disability. There are 77 million of them in the United States alone, and they have an aggregate annual spending power, of $2 trillion. And 51% of people over the age of 65 already have some type of mobility challenge. So again, the temptation is to view people with disabilities as a niche market. What I say when I'm talking to investors is simply this. The body you're in today, it may work as intended, and hopefully it does. Nobody wants to come face to face with disability, but eventually chances are really good that the body you're in is going to betray you. And when it does, do you want to be left behind? Do you want to be neglected as a consumer? Because people with disabilities, we're just like everybody else. If you're in a chair like me, though, you just happen to sit down more, right? But I have the same hopes, dreams, responsibilities, aspirations as everybody else, and I want to be treated as equal, special, being designated as a special group, as it were, or whatever the designation is. Special is not equal. So it's really incumbent upon those of us in the disability sphere and who are members of the disability community to really be our own champions and to really say that we have the power to make a difference. Nothing will happen or nothing will change unless two things occur from a disability standpoint. Number one, we have to coalesce as a voting bloc. And number two, in terms of this discussion, perhaps more importantly, we have to flex our collective economic muscle. So if we do that and we come together and we kind of remove the silos within the disability community, I often, when I speak, I often share that disability is like a high school cafeteria, right? You have spinal cord injuries at this table over here. You have people like me with cerebral palsy at this table over here. You have people with mobility impairments, over here. You have the elderly over here. And in point of fact, until we remove those barriers within our own community and those silos, we're going to be fighting an uphill battle. But when we come together and we recognize our own humanity within that group, and then collectively with a loud but respectful voice, we say to business owners, hey, this is who we are, and this is what you're missing out on in terms of potential revenue. I really think we've got a long way to go. It's important to celebrate the successes we've had, but it's also important to recognize that we do have quite a long way to go. And the only way we're going to solve this issue that we're talking about today is by working on it respectfully in an open, honest environment. And I think if we do that and we put our egos at the door, as they say, we're going to be in it to win it. So that's kind of my story. And if you're having dinner with somebody tonight and they say to you, geez, have you ever met an entrepreneur or a guy who started a business because he wanted to take a shower? Yeah, you know somebody who did that, and his name is Brett. That's exactly why I started Brett Approved Inc. I did not want to be an entrepreneur when I was in school. I never thought about being an entrepreneur, but I traveled so much in my roles as a PR guy and a journalist that it got quite weary going to a hotel and not having what I needed to take a shower and put my best foot forward during a professional presentation. So quite literally, I started Brett Approved Inc. because I wanted to take a shower. And the only way we're going to continue to grow and continue to make a difference in our community and beyond is, as I said a moment ago, to be each other's champions, be each other's evangelists. And again, if we do that, I think the sky is the limit. So without further ado, I will turn the presentation over. Thank you so much.
Thank you, Brett. I appreciate that very much. So my name is Bruna Petrini, and I'm happy to be here today to speak with all of you. I'm hoping that I am coming across. I am here to talk about the Americans with Disabilities Act and to do a little bit of an update for you. I'm very, very happy to be here and to be able to speak on this incredibly important topic. As a lawyer, so often our clients come to us in the business community in one of two ways. Either they are already, there's a conflict of some sort, they're already in trouble, or, very rewardingly, sometimes they come to us when they want to, or they're reviewing some building that they want to be doing, or they are looking at some policies and procedures that they want to either develop or that they are revising, or they are talking to one of their customers or clients and they are thinking about what they could be doing in a better way. And so in those situations, it's an opportunity really for all of us to think about the kinds of things that Brett has talked about and that Rose will be talking about as well. And so it gives us an opportunity, I think, to think about the ADA in terms of what we as business people can do and what we as lawyers and in the legal community can talk to you about, so that hopefully we can look at this issue as something that can be, we can help you to do the right thing, we can help you comply with the law, we can do something that helps you to be cost effective in your, and when you are trying to comply with the law, and it also helps you to, frankly, expand your customer and client base. So with that in mind, that is what we're going to be talking about today. My approach here today was to look at this as an ADA update for 2017. Frankly, most of these issues that I'm going to be talking about are issues that have been coming up repeatedly for the last 25 years or so. So there's nothing particularly new under the sun except for the website accessibility and some of those issues, and we will be dealing with those, I think, when Rose speaks. But in terms of the primary topics that come up all the time for my business clients, they really fall into three different areas. One is the lack of effective communication issues that come up. The other is a failure to meet construction requirements or failure to comply with barrier removals. And the third is a lack of policies and procedures. And so I will be trying to give you an example of each of those situations. First, we're going to talk about effective communication. And the first thing that I want to make sure that everyone understands is that, as Brett was pointing out, since persons with disabilities are unique individuals, as we all are, that effective communication is not one size fits all. That should not come as a surprise to anyone, but sometimes we forget to think about it in that way when we are developing our businesses or our business practices. So some solutions that are relatively easy and straightforward in terms of communicating with a person with a disability in a simple context may not work in a more complex situation. So, for example, in a restaurant or in a retail setting where the nature of the communication is relatively straightforward, whether it be reading a menu item or trying to explain something that can be shown or talked about, then the type of communication that might be necessary is relatively straightforward. It can even be something like, if you can pass a note sometime if someone has difficulty hearing, or it can be something that can be shown to an individual. Conversely, though, if there is a situation where you have more complex information, so if you are in a legal office, if you're in a financial institution, if you are working with a health professional of some sort, then the information that is being communicated is much more complex typically, and often has its own jargon. That's how we get paid, is because we have our own ways of communicating to try to make it more difficult for people. So with that said, that also means that when you are trying to express to an individual what it is, the advice that you're giving, whether it be health advice or legal advice or financial advice or those kinds of things, that communication needs to be adapted to that particular environment. And so you need to take that into account. What is the appropriate communication? In line with that, you also need to consider that not everyone speaks the same language or uses the same form of communication. So, for example, sign language may not be the right mode of communication for every person. And similarly, Braille may not be the right form of communication for every individual, because not every individual may actually read Braille. So you need to actually think about the person who you are speaking with and adapt accordingly. So just not one size fits all. Kind of a use of companions to interpret. I always want to make sure that we just that businesses are aware that as a general proposition, you can't use a companion to interpret unless there's an emergency situation or unless the individual who is there has asked that companion be the person who interprets for them, and the circumstances are appropriate for that interpretation to occur. So, for example, if you are going into a financial institution to request a mortgage, it would not be appropriate to have the minor child be the person who is interpreting those financial documents. That is just not something that would be allowed. So we want to think about those things in advance, and it is just a question of being intentional about what it is that we are doing, and thinking about, will this communication come across? And as a lawyer, realizing or trying to communicate to my clients that in the end you want to effectively communicate, because if the communication is not expressed well, then there will be conflicts in the future because there will be misunderstandings. So effectively communicate, and for businesses, that is how you are able to have your goods and services available to everyone. The next point is a failure to meet construction requirements or to comply with barrier removal. So here we're moving from something where we are communicating about what you do as a business person and being able to talk about your goods and services that way, and you're going to the construction requirements. So we're talking about your brick and mortar situation. And here there are a couple of misconceptions that I know we don't have much time to talk about all these, but I want to make sure that we correct. One is that there is no grandfathering provision in the ADA. And so what does that mean? People talk about grandfathering all the time. Grandfathering is actually a term that is more properly used when you are talking about building codes. It's not something that is appropriate for discussion in the ADA. And so what that means as a practical matter is that under the ADA, you are required to remove barriers that are readily achievable. And that is true even when there's been no alteration or there's no renovation that is planned. So at this point, where we are in 2017, you need to, as a business owner, if you have a piece of property, you are looking at what can I do? What kinds of barriers or obstacles are there to a person being able to enter my premises, get around the premises, and avail themselves of the goods and services that we're providing. If that is really not possible to do, then you can provide what we call equivalent facilitation. So if you really have an older building and it would be incredibly expensive and incredibly difficult to, for example, provide shelving units or something that were lower down to the ground, because you were that would take away most of your floor retail space, let's say. Then you may be able to actually bring your goods to the individual who may have a mobility impairment and may not be able to reach those spaces. But again, those are the kinds of things that you would want to think about and talk to your attorneys about. In addition, I just want you to be aware that there are, when we talk about the types of litigation that has occurred and just the types of issues, I think these are helpful so you see what the types of issues are that come up all the time. You are talking about accessible routes, signage, barrier removal, seating, dining or room dispersion, and line of sight. And the best thing that I can tell you is that as a business owner, just think about when you go to your property, or if you're thinking about building your property, consider what it means for the individual. Think about yourself if you had a mobility impairment, or if you have a sight impairment, or the like. To where would you park, for example? How would you get out of your vehicle? How would you enter into, would there be an accessible route into your establishment? Once you were inside that establishment, how would you be able to navigate around? Would you be able to get to a countertop if that was what was used? Would you be able to see over the countertop? How would you pay? All of those things, and just walk yourself through the day, the experience of actually being in that business, and realize, again, this isn't brain surgery. This is one of those things where we want to be respectful and intentional and open-minded and, frankly, kind. And when we are doing those things, we are typically good business people, and the benefit is that we're also tend to be compliant with the law. So now I'll assume that you've tried to do all those things, but you audited your property, you tried to do some things, and you got sued. Well, even in that situation, I would like you to think about going ahead and addressing any issues that you found, because under the federal statute, you realize that you can actually moot particular claims if you fix the situation that is being alleged. So assume that you did something perhaps unknowingly, incorrectly under the construction standards. You can address those issues and moot some of those claims. So remediation is a good idea. And again, remembering that the general question that we always have for ourselves is, was the person actually able to enjoy, and have access to the goods and services? That's what you want to be thinking about when you get a complaint of some sort. Always, 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 I say to everyone, is do not wait to be sued. The best defense is a good offense. And so check your property and demand compliance from your contractors and your vendors. Put compliance with the ADA and accessibility provisions directly into your contracts. Do not expect or assume that people will do the job the right way or that they know what the law is. Put that into your contracts and hold them accountable. And then do not rely on your building inspectors. They cannot, they do not inspect for ADA compliance. And so you need to know that this is up to you. And if you want to know if something is compliant, then it's up to you to make sure that that is checked. So now I'm going to turn to just a quick issue that is policies and procedure related. And that is it's a perennial issue that comes up, as perennials do, all the time, every year. And this is service animals under the ADA. And I want to raise this because I know more and more businesses are becoming animal friendly, as we've had Amazon and Google and other businesses come into town as well. And so this is something that is coming up. And there is, again, a difference when we are talking about, this is terminology, but a service animal under Title III of the ADA, when you are talking about a place of public accommodation, which is what we're talking about, businesses, that is different than what we were talking about where it was under, let's say, fair housing, which is related to a person's home, let's say, an apartment or the like. So we're talking about a service animal. It's not a comfort animal. It's not a therapy dog. It is not this kind of situation. A service animal under the ADA has a very specific definition. So a service animal under the ADA is a dog or, yes, this is always the fun part, a miniature horse that is individually trained, okay, to work or to perform a task for an individual with a disability. And that disability can be physical, it can be sensory, it can be psychiatric, intellectual, or it can be another mental disability. And keep in mind that an animal whose sole function, and again the key words there being sole function, that is to provide emotional support, comfort, therapy, companionship, or other preference, is not a service animal. But so a service animal could, as part of its duties, provide those services, but it wouldn't be its sole function. Service animals are allowed to be in all of the areas where guests are allowed to be. So if you are a hospital, or if you're an establishment that prepares food, or if you are another kind of establishment that has areas where you normally would think that an animal would not be allowed to go, and you think that there are local and, let's say, perhaps even state health codes that would prohibit an animal from being in a particular place, those codes don't apply to service animals. So again, the service animal goes where your patron or guest or client or customer goes. If a business were to require a deposit, or, and this is where it comes up in your policies or procedures, or a fee to be paid by a patron with a pet, it needs to waive. You need to waive that charge for the service animal, and that is something that we're asked about all the time. But what if an animal causes some kind of damage or the like? That is something different. The service animals need to be under control. Service animals will be house trained. But again, you cannot ask for a pet deposit because, again, service animals are not pets. They are there to assist the person with a disability be able to be in, let's say, the workplace, or in your situation to be able to come and avail themselves of your goods and services. Your staff, so I get asked this all the time in hotels and the like, the staff are not required to provide care or food for the service animals. So if you have someone who is staying at your hotel, it is not that that your staff needs to be going up and feeding and
Hi, Bruna. If you can hear me, it appears that your feed kind of froze there. It might catch up with itself. If you can hear me, please put something into the chat area. Sarah, could you come in with audio so I can see if something's happening on your side? Or Rose, can you nod if you can hear me? Okay. So it appears the captioner can hear me, Rose can hear me. Bruna, you are currently frozen in the video. Oh.
Okay. So
no, continue.
Should I continue or should
we
I
can
not?
hear you now. So please continue. Thank you.
All right. Sorry about that. All right. So, and I'm not sure where it cut off, but there are the two questions that you can ask when it comes to a service animal, and that is the dog or service animal needed because of a disability? And the second question is what work or task the dog has been trained to perform. You cannot ask about the person's disability. You cannot ask about and require medical documentation, or you cannot ask or require special identification cards or training documentation for the dog. or ask that the dog or whatever demonstrate the task or the work that they are that they perform. Okay. The issue that often comes up in the in situations is what if someone is allergic or someone is fearful of a dog. You have someone, for example, in a hotel that says, but I am frightened of dogs and I don't want to be nearby the service animal. The best part of valor there is that you are trying to accommodate both individuals, but in the end, the person with the disability that is covered under the ADA and has the service animal that will override the other person's requests. So the service animal goes. Lastly, and I'm going to make this very, very quick because I know we are out of time, is that I want you to make certain that no one ever retaliates against an individual because they actually raise an issue of discrimination of some sort because they have not been treated fairly, but because of a policy or procedure, because someone has, because they filed a claim because your business was not accessible or the like, because even if they were wrong on the underlying claim, if you mistreat them or retaliate against them because of their charge, they can still win on the retaliation claim. I have added some slides in that I did not intend to go over for you regarding the Arizona litigation update. Those will tell you that very quickly that the Arizona Attorney General is continuing to litigate these cases. They are on appeal at the present time. They were done by this serial plaintiff. My one word of caution for everyone is not to consider all plaintiffs to be serial plaintiffs. Serial plaintiffs are those that typically have one claim that they are bringing, usually something that is very, very simple, something that they can look at by way of, like Google Earth or something, Google Maps, and go in and just take a look at that. Usually it's something like a parking sign height or the like. And they unfortunately give sort of all ADA litigants a bad name. So, and that has spread to other places. So Nevada's AG right now is in the process of going after the serial litigant that is now in the state of Nevada as well. The focus tends to be on hospitality and restaurant claims, mostly for accessible routes, parking heights, and some restroom issues. But again, these litigation, ADA litigation comes in all shapes and sizes. So do not assume necessarily that if you get sued that this is a serial litigant. Instead, please take it seriously. If you receive a complaint, call quickly. There are a number of defenses based on both federal and state law that are very legitimate. If you have a serial litigant under the new Arizona law, there are very strong defenses to that. But if you are but again, don't assume that everything is a serial litigant. And then we end on the good news, which is again to say, when I said a good offense is, the best defense is a good offense. And that is that the one thing that the updated Arizona law did was to add in some tax credits, which were already available on the federal side. So if as a business owner, you go out and you put your house in order and you try to bring your business into compliance or you do things to come into compliance with the ADA, you get a tax credit. But the Arizona law is very clear that if you have actually been cited for non-compliance, then you don't get the tax credit. So the final word is do it in advance so that you get the business, you're doing the right thing, you comply with the ADA, and you get a break on your taxes. So with that, I pass it on to Rose. Thank you.
Good afternoon. My name is Rose-Daly, and I work at the Arizona Center for Disability Law. And we're going to be talking about one aspect of compliance with the ADA, and that is websites. So during it, I want to give you a little information about some recent legal developments because, as Bruna said, there are many developments around websites, and then just some basics, some tips, and some resources about website accessibility and what it means. So when the Arizona legislature was considering whether to exempt websites from our comparable state statute, sometimes people would contact our office and ask us, why do people with disabilities need to use the web? What's important? Why is this an important issue for the community? And our answer is, how many times do you, as a person who is not disabled, use the internet? And that is your answer, because we are relying more and more for information that helps us be a part of our community, learn what is available in our community, and use public accommodations. So we use it to make reservations, make appointments, compare products, check prices and deals. I have a number of ones on this PowerPoint slide. Find the closest location of a store, check hours of operation, get coupons that you can retrieve and use, order prescriptions before you go pick them up. How many of people go on a registry and select gifts that they want to purchase at Target or some other store for a wedding or a baby shower? Or more importantly, or as important, your doctor's office may have a portal that you can get information and communicate more easily with your healthcare professionals. People pay bills, people order online. There's numerous reasons why people need the web. It has become a chief means, and all we have to do is, whether we have a disability or not, is consider how many times do you click on to the web every single day, either through your mobile app, or through your laptop, or a desktop. It doesn't matter. But I will add that for people with disabilities, oftentimes the convenience of being able to use the web simplifies life. For example, I think Brett gave us a really good example, is when traveling, knowing selecting the being able to go online and being able to, if they do have an accessible hotel room, being able to reserve it, being able to look up information. Maybe you have diabetes and you want to look at a restaurant's menu options and the nutritional information in order to make decisions before you go to a restaurant or pick a restaurant that has the best options for you. So it's just many times, but sometimes it makes that ability to find out information before arranging for accessible transportation or making those steps can make life just a little bit simpler for a person with a disability. With respect to recent developments, we could spend the whole hour and 15 minutes talking about it and not having enough time. Some highlights, though, are that in 2015, the Arizona legislature amended the Arizonans with Disabilities Act, which is equivalent to the ADA, to create a coverage exemption for websites. That means that websites are not covered under ASDA. Now, one thing that doesn't change the fact that that amendment does not affect liability under Title II of the ADA and Title III of the ADA. Businesses still can face claims by people with disabilities for a denial of website accessibility or inaccessible website and have an independent claim under the ADA. And one thing that we will say, too, about the fact that the Arizona legislature amended the Arizonans with Disabilities, we are seeing, as Bruna said, more people filing lawsuits against businesses for website accessibility. With the Arizona legislature's actions, that really reduced an option for people to solve problems in Arizona outside of litigation. The Arizona Attorney General, in enforcing the Arizonans with Disabilities Act, reviews all complaints, must investigate all complaints of discrimination. And so the Attorney General, the legislature, by exempting this, means that people can't go to the Attorney General's office to file a complaint and try to resolve things through a complaint procedure and through free mediation available. So it really denies businesses and people with disabilities an opportunity to resolve it more through some other means other than litigation. People can still file complaints under the ADA with the Department of Justice, and as well as file lawsuits. Also, the Arizona legislature did, as Bruna explained, get involved in what they refer to as serial plaintiffs, in some other areas. So if Arizona sees a rash of lots and lots of website accessibility cases, I don't know if the Arizona Attorney General would have the same option for website cases because they don't have jurisdiction anymore since they made it exempt. The Trump administration also has placed website accessibility rulemaking under Title II and Title III of the ADA on the inactive list. So each year or I think several times a year, there is a unified regulatory agenda, which means that rules are proposed rules to provide more information about a particular law and to provide more details are proposed and then reviewed for obtain public comment, and then make decisions about what the final regs will be before adopting them. But the Trump administration has decided that it will not. It will place that on the inactive list. What does inactive mean? That term was not defined, and it's a new term that the administration is using in the agenda. However, it's not exclusively done to ADA issues because at least another 100 active actions were reclassified as inactive, which address many more issues. What I think it does, what the website for the Unified Regulatory Agenda says is that it's going to allow for more careful consideration of things placed on the inactive status. But as we'll see from more legal developments, court decisions are filling in the gaps that the regulations, that the absence of regulations created. So some courts have recognized that it would be nice if the Department of Justice provided us with regulations, which we now see is not forthcoming in the any time in the near future. But courts can have decided that they can look at this issue, and they can make decisions and fill in some of the gaps that regulations would fill in. So on this slide, I have given you a number of cases. All of these on this slide, it involves Target Corporation, Scribd, MIT, Harvard, Winn-Dixie Stores, Hobby Lobby, Five Guys Restaurants, Blix, which is a art supplier with online art supplies as well as retails, J. Lindenberg Inc., which is a clothing manufacturer, Bang & Olufsen, America, which sells audio products, and Domino's Pizza all experienced lawsuits claiming that their websites were not accessible. In all of the cases except the last two, courts allowed a case to either go forward or passed an attempt by the business to have the case dismissed at the early stages. All of these went forward, and in the decisions that courts reached in terms of saying, why are we going to let this case go forward, they ruled that the ADA and Title III of the ADA, which covers businesses, does permit, it does say that websites are accessible. And in addition to these companies, the Department of Justice has entered into various settlement agreements, obtaining agreements to make websites accessible with other companies, such as the producers of the Price is Right show, H&R Block, the Law School Administration Council, which administers a test for people who wish to go to law school, and edX, which is a producer of educational materials, etc. So in addition, these cases have reached different reasons why they say the websites or the extent to which websites are accessible, but there is a growing trend for courts, and the trend is more towards people with agreeing with people with disabilities that websites need to be made accessible under Title III of the ADA. The information we can take away from some of these court decisions are that one is we have to take away the idea that none of these cases most of these cases are not decided by any Court of Appeals. So they do not have precedential value, and other judges can make different decisions. But they oftentimes look at the decisions that have been made in a new area of law to look at the reasoning. And there is some disagreement among the courts about website accessibility, but the disagreement is not whether a public accommodation may be covered by the ADA so much as whether an inaccessible, when we look at whether or not an online business that is online only can be covered, or if it is only to be, or we only look at websites of businesses that have a brick and mortar location which has a physical place that people go to. And all of this is because of a word in the ADA Title III, and that's place of public accommodation. The ADA applies, Title III applies to places of public accommodation, and places of public accommodation, courts have focused on whether that means a physical location. And so many courts have had to grapple with that issue, but few have said that websites are not accessible. In the Domino's case, the court said that they wanted to wait until DOJ issued its regulations, but in other words, except for all the other cases that have let this go forward, let website cases go forward, they have said it's really about whether or not it's a physical location. And there's really a split among the courts about under what conditions a website is accessible. Now, Arizona, businesses in Arizona, they have to follow the case law in the Ninth Circuit. And here's how the Ninth Circuit is answering this question. A case was filed in the Ninth Circuit against Netflix, asking for them to make their online material available through captions. And the Ninth Circuit ruled that there has to be some connection between the good or service complained of and an actual physical space. Because Netflix services are not connected to any actual physical space, it's an online business only, Netflix was not subject to Title III of the ADA. How cases in the Ninth Circuit have looked at this is they have, oftentimes followed a case involving Target that resolved without going to the Ninth Circuit. It settled soon after a decision trying to dismiss the case. But the National Federation of the Blind brought a case, and they said the inaccessibility has to impede, as Bruna said, important words, full and equal enjoyment of goods and services offered in Target stores. And there they noted many of the things we looked at when I talked about why does anyone need to use that. Look up a store location, look up store hours, get a coupon that you can retrieve and use at the store, submit, file, make a request for your pharmacy prescription, call your order in. All of those kinds of things creates that kind of connection as the court in the Target case noted. If DOJ has not adopted regulations, then what are businesses supposed to do anyway? How are they supposed to evaluate their accessibility? Well, Bruna raised one issue, and she said you have to look at how things are used by people with disabilities. And there is actually a Ninth Circuit case that talks about that. The case is supposed to be what the standard is, and it wasn't in a context of websites, but it said you have to look at the experience of how people who are not disabled are experiencing it, and you have to make that service as close to and as possible to that of people who are not disabled, and you also have to make sure it's not more onerous for a person with a disability to enjoy those services than that. I would add that, but still, that's not very practical. How can you learn more about what you do? Well, the Department of Justice and a recent trial court decision in a case involving Winn-Dixie, a grocery chain, and another I don't think they're in Arizona, but the Winn-Dixie's stores, they applied the WCAG 2.0. And that is sometimes when government doesn't create a standard, private, either nonprofit entities will fill those gaps, and that's what's happened. WCAG stands for the Web Content Accessibility Guidelines, and a nonprofit initiative from the Worldwide Web Consortium, the W3C, they created international standards. And those are the standards that the DOJ requires in all of their settlement agreements, and that the court, the trial court in Winn-Dixie case, which is the first case that's looked at a website accessibility matter, that's what they required once they found that the website was inaccessible. I do not pretend to be a techie, nor do I pretend to be an expert on website content accessibility guideline, but I do say that it is it is based on this WCAG 2.0 is based on 4 principles, and that is that that content on your website is perceivable, that content on your website is operable. So perceivable, I'll step back a minute, means available to all the senses. So if you had that goes towards enlarging font, being able to have the ability to change the size of the font so someone can see it who has a visual impairment, being able to have audio descriptions on some things, that content where it's pictures only or video only, for people who are deaf or for people who are hard of hearing, having captions, and it could possibly even mean having ASL translations for other types of content. Operable also means that you can interact with it with all controls and interactive elements using the mouse, keyboard, or an assistive device. Understandable helps a lot with people who may have learning disabilities and intellectual disabilities, but the content is clear and it limits confusion. So it's about writing in plain English, using simpler sentences, shorter paragraphs, bulleted points of information. And it's also that the web content will be robust, that a wide range of technologies, including old and new user agents and assistive technologies, can access the content. Now, I have provided you, and I'm not going to go over it on this one, but a website link to UC Berkeley, who studies website accessibility, and they give 10 tips for starting out on accessibility, creating an accessible an accessible one. And one thing, and this PowerPoint is going to be also available to you, but I'll just give an example of one, and that is using your color palette with care, so that oftentimes looking at the best contrast for people with visual impairments may mean having it on black and white, black print on white, or yellow on black, etc., and that you have a good contrast between colors. It also means making dynamic content accessible, so that's what we're talking about if you have videos and videos, etc., on your videos and audio recordings on your website. And it also means organizing information in ways that people who use screen reading software, which are oftentimes people who are blind, use screen reading software that reads the audio content, but information has to be organized in a way that it is not laborious to use your screen reading software to do so. I know I'm going to leave time for questions, but I just had a couple of things. Since I believe it was in June, we had the first trial verdict in a case involving the allegation that a business was not accessible, that a website's business was not accessible. And so I thought it might be a useful lesson. Again, it's not an appellate court that's ruling on this order, but I think it gives us some ideas of what a court expected once finding that a grocer's website was not accessible. These are the things that they ordered in that particular case. It was for one thing, it said that websites must be accessible by individuals with disabilities who use computers, laptops, tablets, and smartphones. And that's the robust one of our our 4 elements, POUR or poor, that's the robust part. It also, as I said before, we don't have DOJ standards, but it required their website to conform to WCAG 2.0 criteria. That means that it was a kind of a little bit of a safe harbor for people if they used that. This is may be very interesting to businesses and to people with disabilities. Sometimes we hear, I can't, that part of my website is not is inaccessible, but it's because I have a vendor or a third party that is on there and they are not fully accessible. The judge in this case required them to that they said that the company shall require any third-party vendors who participate on its website to be fully accessible and to use those criteria, the same criteria. Also, one of the things required, and this is something recommended by people, this is something recommended by the W3C standards, and that is you should make a statement available about, you provide an accessible means for people to say, I'm having trouble with your website. So you basically have you make sure that part's accessible and that people can then call you if they have a problem with their website, and they can report it to you so that you can then make changes. So that's getting on a regular basis input from the community. Also, they required training, which is oftentimes what we see in ADA cases. For all the people here, who needs to be trained? All the people who write code or develop programs, because when things are updated, you want to keep using the correct standards when you add new content to your websites. In this particular case, the Winn-Dixie case, the company had spent $7 million on updating its website to add some new information, new programming, etc. on there, and they didn't look at website accessibility. And so then at the trial, they tried to say spending around $200,000 would have been an undue burden for them to be able to do so. And based on the fact that they had invested $7 million in their website to make changes, and weren't willing to look at accessible things, appeared to impact the court's decision. The other thing is they required them to conduct automated accessibility tests on it, which are free and available through this W3C consortium. I don't know if you can see this as well, but we just had, and by no means do we say that we are perfect. The ACDL is working on its website. We just added something yesterday to improve things. But one thing that you will see up at one point is that we have ASL, the symbol for signing, and then people can click on that and view anything we have in ASL. At the top where you see 3 A's, that means you can change the font size. And again, we've been advised about how to organize this. This website is an overhaul because our information was not organized in this fashion before in order to make it easier to use by people who use screen reading software. This is just an example that some of our guides, and we're continuing to do that, but guides we're putting into American Sign Language, so we're making dynamic content available in sign language and captions. And one last thought before we take questions is just to say that it's really important, even if you use someone who is a web designer, use a platform or use it that's accessible, and you use people who know what they're doing in terms of coding, etc. It's really important to get feedback from people with disabilities. That's something that we did when we overhauled our website, was to not only use website checkers, but you can find errors that people with disabilities can do exactly what the Ninth Circuit said, tell you how people with disabilities are using this and what's working and what's not working. They can also increase understanding of how they use your website. It can make for better customer satisfaction. It can increase the number of site visits, and it can improve the experience, and maybe people will get more positive reviews on Brett Approved as a result. And I'll turn it over for Sarah to lead us on some questions.
Great, everybody. Thank you so much for all of our speakers' info. John, will you help me answer some of these awesome questions that have come through the chat box? And if you've been holding on to them as you've been listening, and if something's popped up into your mind, go ahead and type those into the chat box now. We do have a question from Andrew Robinson. Andrew asked a question about I believe it was service animals, when Bruna, you were talking about the laws surrounding service animals, and he asked if those laws applied to apartments. Would you like to tackle that one?
Bruna, if you can hear me, I think you need to click your microphone icon again.
Does that work? Yes? Are we there?
It's coming in a little bit clearer now. Yes, perfect.
Perfect. All right. So the apartments are covered primarily under the fair housing laws. And so the term there is not service animals, but there are similar types of provisions. They're a little bit broader, actually. So there are more animals that are allowed to assist persons with disabilities under the fair housing laws than there are in places of public accommodation, precisely because, again, you were talking about a person's individual home. Then there are parts of apartment buildings that can also be places of public accommodation, but in terms of the living quarters, if that's what he's asking, then that is covered under the fair housing laws. Now I can't hear others.
Sarah, if you could unmute yourself, we could hear you.
There we go. Much better. All right, so this question is from me to all of the speakers. What would you say is the #1 mistake that businesses, either brick or mortar businesses or ones that operate online, what is the #1 mistake they make when it comes to the ADA?
Well, I'll start with website accessibility. I think that that's a difficult question. I think the most important thing that, because there's so many ways you could do something wrong on a website if you haven't done anything. But I think the first thing is to assume that their websites are not covered because of the recent decision by the Arizona legislature, because even though ASDA doesn't cover them, you still have potential liability under the ADA. And the second thing, I think, is thinking that it's impossible to do, or that it's so difficult to do that they don't attempt to do it. So I think talking to someone who is knowledgeable about that and you know, if you have to consult with someone, those are the most important things. Is you can tackle this. It is not, it's not out of the question to be able to accomplish making an accessible website.
Yeah, and Sarah, I think in terms of my experience, the biggest mistake that businesses make is just simply underestimating or not being knowledgeable about the market. So obviously we talked about travel in my portion of the presentation, but I just wanted to read a stat to you. Globally, when we take into account that every person on the planet with a physical disability or some type of disability their friends and colleagues and family members. This represents 2.42 billion customers worldwide who control collectively 6.9 trillion in discretionary income. So $6.9 trillion, that's a lot of money. And if we break that down in terms of people with disabilities in the United States, we have $645 million, or $1 billion, excuse me, in discretionary income. So I think there's a misnomer among businesses that people with disabilities don't have money to spend, and that is simply not the case. I mean, even if we're tackling, half of 1% or 1% or 2%, I mean, there's not a business on the planet that wouldn't want to increase their bottom line in terms of those numbers. So just knowing as a business person, whether it's brick and mortar, whether it's online, whatever the case may be, this is a demographic, that is to say people with disabilities, that has money to spend, will spend it, is incredibly loyal, and is growing every day.
I would just add one quick thing too to that, is that, and your website is your gateway. I mean, so many people visit a website before they come to a place of business. So if you want that discretionary funding, you want to attract the clients and those customers, you want to, your first opportunity to introduce yourself as a business that is disability friendly is your website.
And I would absolutely echo what both Rose and Brett have been saying, and that is that I would ask most businesses not to think that this is an incredibly difficult endeavor, and that it is not an incredibly high hurdle. It is really just a way of reaching out to a much, much, much broader customer base, and it is your first impression for people. And it is, again, something I think businesses are scared off and assume that it is something that is frightening and that that it's difficult for people to understand. But when I bring this to tech people, they're like, okay, yeah, got it. This is not that complex. And then it just so if you run a restaurant, you don't need to understand your website necessarily. You just bring it to your tech people, and they can do that for you. And then people know that they can get into and reserve tables and and do all those things and access movie theater tickets and and everything else online.
And at Bruna Approved, we're committed to this so much that one of the things we do, one of our business verticals, is what we call soft skills training. So if you're a business owner out there and you're a little apprehensive about, what do I say? How do I interact? What do I do when a consumer with a disability comes into my restaurant or wants to leverage my services? Go ahead and reach out to me, brett@brettapproved.com. And let me know, because we'll come in and do some training, and it's a safe environment, it's fun, it's non-judgmental, because ultimately at the end of the day, our job at Brett Approved Incorporated is to make sure that as many people as possible, regardless of their disability, live the life that they've imagined. So we're here to help.
Great answers. Thank you, everyone. We have another question from Andrew. There are limits to accommodation, he writes. For example, sensory issues with people with autism. So what kind of limits might that propose? What kind of challenges as we move into a society that acknowledges and embraces and really is seeing a lot more people with autism and seeing kids with autism grow into adults? Have any of you encountered this with your work?
Yeah, I think, at Brett Approved, we try and meet the needs of everyone, regardless of where he or she may live on the spectrum of physical ability. And, I'm certainly not going to position myself as a scientist, but there has been, over the course of the last 30 years, a dramatic increase in folks living with and being diagnosed with autism. And so to me, it's all about being as inclusive as possible. And so if anybody visits brettapproved.com and there's a challenge of any kind with reading or any issue whatsoever, I would encourage them to contact me directly or a member of my team. And regardless of your challenge, I will sit with you, or a member of my team will sit with you and make sure that we answer every single question that you have, so that regardless of your challenge, whether it's autism or something else, you get the consumer-focused information that you need. Again, we're all very busy, but if we put an effort and make an effort to include everyone, amazing things happen.
And I would, picking up on that, we talked about the fact that disabilities are, very unique, and that it is, you look at each individual. So, well, under the law recognizes that. So when we are talking about accommodations, it is, you are making accommodations, the accommodation process is an interactive process by law. And so the business is in the position of knowing more about their individual business, like what can be done within the confines of, what their goods and services, or what they're trying to provide. And the individual is the expert on their disability. And so, again, because there's, even when you talk about autism, there's such a broad spectrum that, if someone were coming and discussing, what kinds of accommodations could be made, and autism, depending on where they fall on the spectrum and what they need, you would be having that interactive discussion to see what could be accomplished, so that you try to, it's not, again, a one-size-fits-all type of situation. And if you're talking about a website, that again is slightly more complicated, although it would be, I think, trying to keep some things off of, websites that might create sensory issues for an individual with, a particular disability, and trying to, and maybe Rose can speak a little bit more to that than I can.
Well, one thing I would add is that I think for people, like we saw, auxiliary aids and services is something that it primarily helps people with sensory disabilities. It's primarily targeted at making sure that people with sensory disabilities have access to information, and the barrier removal and the construction requirements oftentimes assist people with physical disabilities, but a little more broader. But there is another provision of the ADA which requires reasonable modifications of policies and procedures, and that's how we get the service animal requirements. They go from there. And so that's sometimes what we need for people with disabilities or with autism. We might need something to be done a different way than it's done for other people, or an exception to a policy or way things are usually done. And all of the things that Bruna said about it has to be interactive to come up with that. But that's one part of the ADA that really provides information for people with disabilities. Sarah's drawn your attention to an article about Disneyland. I did read a case about a cruise line who had a teen area where there was music and very loud music and strobe lights and things for teen activities, and the cruise line, that was affecting some of the teens with autism. They were the music and the things the strobe lights were that. And a court said they didn't necessarily have to change those things because that would have been fundamentally altering the teen thing, but they did have to waive a fee so that they could have another room and create an environment that worked for them, and that normally they charged anyone who got one of those private rooms $250, that they would not charge that group that, because they needed this in order to enjoy the cruise's amenities and create an environment that worked for them in terms of some of those teen activities. So it can be different things, and not that I'm suggesting that segregation, because that was kind of a weird one, but there are other ways in which rules may need to be modified in order for everybody to be able to enjoy something.
Those are great thoughts. Thank you, everyone. Looks like we have one final comment from Angelina. Angelina writes, with rural communities, I have noticed that for people in self-employment, they use social media to like Facebook pages and to advertise in various yard sales. They also post for people who are not computer literate. So that's something we haven't really touched on much, which is the role of social media with Facebook and Twitter setting and increasing their own accessibility standards. You know, that's a new frontier. You know, we got your website, but what about your Facebook page and your Twitter account? If anybody has had experience making that accessible, I'd love to hear your thoughts. And then I believe we'll wrap things up.
Yeah, I just think in terms of social media, in terms of what we do at Brett Approved is, you know, unfortunately for a lot of folks having living with a physical disability can be kind of isolating, right? You can oftentimes perhaps feel that you're the only one, or there's perhaps nobody else like you. I know I grew up in a small town in northwest Ohio, really close to Detroit, and when somebody visited my school and said, hey, where you guys sit on diversity, they would pull me out of class and make me wave, right? So there were no people with disabilities besides me. And, you know, having social media and, you know, being part of a community that, yes, you know, we're all different and we have unique needs, but there's also that commonality that we're all in this together. And so if you're, you know, kind of feeling, you know, lonely or you really want to leverage social media, I would just encourage you to jump on Facebook, find a respectable group, and then, you know, ask questions of that group. And, you know, I think it'll help quite a bit in terms of the accessibility of our Facebook page. You know, and as far as my knowledge goes, I think Facebook keeps pretty tight controls over what we can do in terms of accessibility. We do try and, you know, use bolded fonts as much as possible and things like that, but I'm by no means an expert, but I think Facebook is pretty tight about what you can do and what you can't do in terms of accessibility. If I'm mistaken, you know, if one of my fellow panelists could correct me, that'd be great.
Bruna, did you want to address that?
Well, I'm thinking as we're doing this, and that is one that, you know, as a platform, I'm not certain that, you know, the law is yet there in terms of regulating, you know, the likes of Facebook and other social media platforms. However, having said that, I think that as it becomes a primary medium for a lot of, you know, if there's a lot of retail sales and other things that are connected to brick and mortar stores, for example, that occur on, you know, where you are almost forced, I want to say, into, you know, the Facebook or something like that to do a purchase or to do, you know, or to get a sale price or to do something like that. That I have not followed, so I'm not familiar. I have not looked at it. We'll have to just be upfront here to see what that case law is, if there is any there. But I would anticipate that would, if it's not there yet, would be forthcoming. And just as members of the disability community, I would think that there would be a place for putting some pressure on, frankly, you know, Facebook and others to say, to the extent that they regulate things, you know, perhaps it's an unnecessary regulation on some of those requirements so that they could allow for more accessibility. That may be an unintentional consequence of some of their other regulations.
And I would add that I've seen a lower court decision that said Facebook wasn't covered, but that was because it was in the ninth. It was a lower court decision in the Ninth Circuit, and they relied on that distinction I told you where it needs a brick and mortar store. But just because Facebook can be sued in other jurisdictions where they don't have that restriction. And I'm going to just refer back. I told you that there was a Netflix case in which the Ninth Circuit said Netflix isn't covered, but another organization brought a lawsuit against Netflix, I believe in Massachusetts, and that case was allowed to go forward, and actually Netflix started adding, you can see more captioning and stuff on Netflix now. So even for online types of environments, if they're sued in a different jurisdiction, that same decision might be different. The other thing is, I think one thing is what Bruna is saying, though, is the only thing covered by title, employers are covered by the ADA, public accommodations are covered, and state and local governmental entities are covered by the ADA. So if it fits into a category, or if it is used by one of those entities, like a business, to provide services or to be able to enjoy services in their brick and mortar store, then it possibly could be covered, and the law will probably develop more in that area.
Yeah. And so, to kind of tie back to one of the things I was trying to say in my presentation was that I'm a big fan of trying to resolve some of these issues, in advance of litigation. And so if it's possible, and this is something that is coming up more and more, I would say that there is, I had not considered the fact that Facebook may have some regulations that prevent people individually from, or some rules, I should say, from individually making their own Facebook pages more accessible. But that would be something, it seems to me, that as a group, there would be some power in, raising those sorts of issues and addressing those, if there is a way that can be done with a lot of those, media platforms. So.
All right. I want to thank everyone for your participation, and Rose and Bruna and Brett for all of your insight